Welcome, everyone. Thank you for joining us on today's webinar and training by Alliance for Justice and Bolder Advocacy. My name is Casey Ann Carbonell, and I'm Director of People and Culture at Everyday Impact Consulting. This is the first of 3 trainings we'll be offering this year with Alliance for Justice. Today's topic is Public Charities Can Lobby, How Your 501c3 Can Influence Policy for the Greater Good. And this session aims to equip organizations with the knowledge and tools needed to legally and effectively advocate for policy change. So this training is being presented in partnership with the Central Valley Solidarity Table, a group of AA-NHPI community-based partners across the Central Valley, working across diverse issue areas such as immigration, rapid response, environmental justice, youth development, anti-Asian hate, cultural organizing, and more. These partners include Jakara Movement, Little Manila Rising, Chan BOF, Apsara, Central Valley Pacific Islander Alliance, as well as EMAC, Amado Kaya Initiative, and Central Valley Empowerment Alliance. This training series is also in partnership with the Be Bold conference and initiative by Everyday Impact Consulting. This training will be 60 minutes, and then we'll have Q&A for 20 minutes. So please drop any questions into the Q&A in Zoom, and our team will help to triage them. And this training is being recorded, and we will share this recording with all those who registered. So today's facilitators include myself as well as Katie Valenzuela. I've already introduced myself, so I'm going to pass it to Katie. But before I do, I also wanted to introduce the rest of the team who will be supporting today's webinar. So we have on our support team, Chloe, George, and Vince, our CEO, is also on the call. And we're really excited to be offering this training series to you all this year. So I'll pass it to Katie.
Good morning, everyone. My name is Katie Valenzuela. I use she, her pronouns. I'm the policy consultant for and to be kicking off this first series. My role at EIC is to really help our clients who are trying to engage in policy work. And I'm at a hotel with another client for a conference, so if my internet blips, I'm sorry. But definitely excited to hear that so many of you are interested in this, because your voice at this time is so necessary to inform policy that is going to serve your communities, that's going to meet your community needs, that are going to ensure that the legislature and that your local city councils or whoever you're advocating with is really making sure that your communities are heard. And you as a 501c3 have an essential perspective that is really needed in that process. I've seen bills stop in their tracks because community members come forward and say, wait a minute, this isn't what we want. I've also seen bills move forward because there weren't community members who were there to express their concern or ideas. So really excited you're participating today. And as we get started, we'd love to invite you to put your name, organization, and pronouns in the chat, and also where you're zooming in from, so that we know who's here, and you can see a little bit about each other. And yeah, I think that's it. So now I get to pass it over to the AFJ trainer and counsel, Brittany Hacker, who will be leading us through the training today. So thank you so much all again for joining us.
Thank you. So let me just share my screen. All right. So thank you so much. My name is Brittany Hacker, and I'm one of our attorneys at Bolder Advocacy, which is a project of the Alliance for Justice. I'm joining you all today from DC, and I am very excited to be talking to you all about lobbying regulations for 501c3s and all the lobbying that you can do while still following the IRS's rules. So a couple notes to get started. This presentation is being recorded. I'm going to send out copies of these slides after, so don't feel like you have to take too many notes. And I'm also going to send out links to the resources that we discuss in this training. So all that will be coming your way afterwards. And throughout these slides, you'll see QR codes. Feel free to scan them as we go along. But again, we're sending these slides out, so you'll have the QR codes to access our resources later as well. So just an introduction to the Alliance for Justice. Hopefully you've heard of us. If not, we're an association of over 130 organizations that care about creating an equitable, just, and free society. We build the strength of progressive movements by educating nonprofits, and we work to transform our federal and state courts to be representative of all of our communities as well. If you're interested in becoming a member with us, you can learn more on our website. And at AFJ, our Bolder Advocacy team, which is where I work, is a team of attorneys who do training and education and workshops like this. And we also offer free technical assistance. So in addition to the information I'll give you today and the resources I'll give you afterwards, we have loads of more free resources on various topics affecting 501c3s, and all that can be reached on our website through this QR code. And just a quick disclaimer before we get started, this presentation is not legal advice. It's for informational and educational purposes only. I'm an attorney, but I'm not your attorney. So if you need a formal legal opinion, you should contact your organization's attorneys that you normally work with and someone local to your area. We're also going to focus today on IRS law, so be sure to always consult other areas of law like your state and local laws, federal election law, if you're making any big moves. We say these IRS laws are just the top layer of the onion, so make sure you just check out those other layers as well. Okay, so today's agenda, first we're going to have a little introduction into the different types of tax-exempt organizations, their benefits, their limitations, and the rules that apply to them. Then we're going to discuss the limits on lobbying that are imposed by the IRS and how you can track and follow those limits. And to understand those limits, we're going to spend a good chunk of time talking about what counts as lobbying, what doesn't count as lobbying, and what's going to go towards those limits. So what's the difference between advocacy and lobbying? Advocacy is all of the great activities, communications, things you do that support or oppose an issue. It's a tool that you all are using every day, and lobbying is just one type of advocacy. So we're going to delve deep into the definition of what counts as lobbying, but for right now, think of it as efforts to influence legislation. That's either by talking directly to legislators who are making law or by talking to the public and telling them to talk to legislators. So we'll talk a bit more about that, but just keep that working definition in your mind. Both nonpartisan advocacy and lobbying are allowed for 501c3s. Lobbying just has a few extra rules that apply. So that's what we're going to talk about today. And we're going to make sure you know those rules so that you can safely and effectively maximize how much lobbying you can do and be confident in the work you're able to do. So here's our exempt organizations chart. In day-to-day speech, we say nonprofit to encompass a lot of different things. It actually includes 27 different types of nonprofit organizations. So this chart just has two that we're going to talk about today: 501c3 public charities, the first column, and 501c4 social welfare organizations. So 501c3s have the most preferential tax treatment. They are tax exempt, and the donations that donors make are tax deductible. So in exchange for that most preferential treatment, 501c3s agree to have limits on their lobbying, which you see here in yellow, and they agree to some limits on their electoral activities as well, which you see in red. So all electoral activities must be nonpartisan, which means you cannot support or oppose a candidate for public office. But 501c3s can do nonpartisan advocacy even during an election season. We have a lot of training specifically on this issue of nonpartisan advocacy if you're interested in learning more about that as well. And then in contrast to the C3, you can see in the next column, 501c4s have an unlimited amount of lobbying, and they can conduct partisan electoral activity. It just needs to be their secondary purpose. So they have to have a primary purpose that's not partisan election activity. The drawback for a 501c4 is that contribution that donors make are not tax deductible. So a C4 is good to have in your coalition. They can address some of the things that a C3 might not be able to. They're a good partner to have, different benefits for each. And then just one note, so private foundations, which you may work with, they are also 501c3s. but they follow some different rules when it comes to lobbying. So just keep that in mind. If you're at a foundation, if you work with a foundation, their rules are a little bit different than those for a public charity. So this image visualizes what I just described for the 501c3, that first column we were looking at. Partisan political acts are that red light. 501c3s cannot do partisan political acts. And that yellow light is lobbying, because there is a cap on how much lobbying a 501c3 can do. But just like a yellow light when you're driving, you can go through a yellow light. You just have to be a little cautious and know when you shouldn't go through it. And then we have all of these great advocacy areas in green that are totally unlimited, things like litigation, education, research, training, lots of things a 501c3 can do that the IRS does not put caps on. Okay, so let's delve into lobbying. We're going to talk about the limits that apply to 501c3s and their lobbying. First, we'll talk about what the limits are, what those caps are, and then we'll drill down into the definition of lobbying to discuss what's going to count towards those limits. So there are two different options for measuring your lobbying that the IRS offers: the insubstantial part test and the 501h expenditure test, which is an election you can take. Which of these tests you choose to use will determine what your cap is, how much lobbying you can do, and what's going to count as lobbying. So if you're not sure which of these you're using, you can check Form 1023, or you can look at your Form 990, Schedule C, and if you're filling out the part that says 501H, that means you've made the election before. So first, the insubstantial part test basically says that no substantial part of a charity's activities can be influencing legislation. That's kind of a more vague definition. This is your default test for a 501c3 public charity. So if you formed a C3 and you did nothing else, this would be the test that's measuring how much lobbying you can do. So the IRS under this test is going to look at all of your activities. So that includes things you spend money on, but also softer factors like time and energy. So that means that things like volunteer time and effort is going to count towards lobbying as well. Again, this definition is a bit less clear. The IRS hasn't said exactly how much insubstantial is, nor has Congress, but opinions from the IRS cases have indicated that insubstantial is somewhere about 3 to 5% of your organization's total activities. And then in contrast, we have the other option, the 501h expenditure test. This is going to make sense for a lot of 501c3s to do if you haven't taken it already. So to use the 501h expenditure test, you make a one-time election with Form 5768. This lets the IRS know that you want to use the 501h test to measure your lobbying instead of the insubstantial part test. It's a very easy form to fill out. It's half a page. I swear it's the easiest form that the IRS has. And you just fill it out once, and then you can use the 501h test forever until you let them know that you don't want to use it anymore. So this isn't going to change your status as a 501c3. You're still a 501c3. You just will be using the 501h test to measure your lobbying. So the benefits of the 501h test are that they provide a really clear definition of what counts as lobbying, and they only measure dollar-based spending on lobbying, which makes it a lot easier to track and to know how much you've exactly spent on your lobbying work. So it's not going to look at your total budget. It's not going to look at all the money you bring in and all the money you put out. It's just dollar spending on lobbying. And that means it's not going to include volunteer time. So if you have a lot of volunteers you want to engage in lobbying, none of their effort will count towards your lobbying limits, which is really nice. And we have a great resource on our website called Keeping Track. This QR code in the corner links to it, but basically goes through the details of how you can track your lobbying and what you need to be keeping track of to know what those dollar expenditures are. So for most 501c3s, taking the 501h election is going to increase your lobbying limit. So if you're hitting your cap under the insubstantial part test, it might be a good idea to move to the 501h election. Just one note, the only 501c3s that cannot do the 501h election are houses of worship. So if you're working in coalition with a house of worship, just keep that in mind. They'll be using the insubstantial part test. So here's a chart that's a little example, and these numbers kind of get confusing. So if you want to see what your limit would be under the 501h test, you can follow this QR code in the corner. We have a calculator where you can plug in your exempt purpose expenditure, and that'll tell you exactly what your cap would be under the 501h test. But in general, if your exempt purpose expenditure is $500,000 or less, your lobbying limit is going to be 20%. So that is going to basically, as your exempt purpose expenditure increases, the percentage decreases a little bit, and it goes up to a maximum lobbying limit of $1 million and that's for organizations with an exempt purpose expenditure over 17 million. So very, very large. If you have an exempt purpose expenditure of over $17 million, that is the small group of people who might actually be able to lobby more under the insubstantial part test, because at some point 3 to 5% of your total activities might go over $1 million. But for everyone else, the 501h test is probably going to increase how much you can lobby. And then just a note, so that second column here includes two different types of lobbying: direct lobbying and grassroots lobbying. And we'll talk a little bit more about the difference between those two, but just know that under the 501h test, only a quarter of your total lobbying can be grassroots lobbying. Under the insubstantial part test, they don't distinguish between the two different types of lobbying. So just keep that little peculiarity in mind. So here's an example. If a 501c3 elected to use the 501h test and they had an annual exempt purpose expenditure of $500,000, the overall lobbying limit would be 20% or $100,000. And then of that $100,000, up to $25,000 could be spent on grassroots lobbying, and the rest could go towards direct lobbying. Or you could use all $100,000 for direct lobbying, but it could only be a maximum of $25,000 for grassroots. Again, we have a helpful calculator if you want to see what your limit would be under the 501h test. Check that out on our website. So as a note, most organizations are not getting too close to these lobbying limits. They are pretty generous, so don't be too concerned about hitting it unless you're doing a lot of lobbying. There are just a few things you want to keep in mind when you're keeping track of your lobbying. The IRS hasn't said how to specifically track your lobbying, so you just want to do it consistently and in good faith. Use whatever system makes sense for you. For example, we use our timekeeping system, so when we log time, we just categorize it as lobbying if that's what we're doing, and that keeps track of all of that for us. You just want to have a consistent record that you would be able to show if you were to get audited, which is not common as well. And once you've recorded your lobbying, you need to report it each year on your 990 to the IRS. And just a final pointer, you want to make sure you're only using funds for lobbying that you are allowed to use for that purpose. So a lot of times private foundation money might have a prohibition on lobbying. So just keep that in mind. Move that money around for other purposes if you need to. Just bear in mind that you want to make sure you're always using funds that allow your lobbying. Okay, so in addition to these IRS limits, you might have to disclose or register at different levels of government. So we have the IRS limits. That includes lobbying at all levels: federal, state, local. It all goes towards that one IRS limit. But your state or your city might want you to register as a lobbyist if you cross a certain threshold. So just keep in mind, if you're going to be lobbying at the state level, for example, check out their website, see who regulates lobbying, who counts as a lobbyist, what's the threshold where you would have to register. Just if you're going to lobby, check out that level of government's rules. They're not going to have a cap that's greater than the IRS or lower than the IRS. So the IRS limit is going to be your limit. You just might need to register as a lobbyist at these other levels. Okay, let's talk about that definition of lobbying. What's going to count towards these limits? Under the insubstantial part test, as I said before, the IRS does not distinguish direct and grassroots lobbying. And it provides this kind of vague definition. So, lobbying is a communication to lawmakers to influence legislation or encourage the public to contact lawmakers to influence legislation. That's pretty broad, but you kind of get the sense there that it's including both talking directly to legislators and talking to the public to tell them to talk to legislators. The 501H test, by contrast, has very clear definitions. So we'll go through each part of this to discuss what's going to count exactly as lobbying. Again, they distinguish direct and grassroots lobbying. Direct lobbying is a communication to a legislator that expresses a view about specific legislation, and grassroots lobbying is a communication to the general public that expresses a view about specific legislation and includes a call to action. So grassroots lobbying is different because it's directed to the public and it has that call to action. And we'll go through that a little bit more so you know what each of these factors that you need means. Okay, so communication, this is required for both direct and grassroots lobbying. This is not a legal term of art. It's any way that you are getting your message across. So it could be social media, virtually, it could be talking directly to a legislator at the Capitol. It could be writing a letter. It's any way you're getting your view across. And keep in mind that you want to keep track of not just the moment that you're talking to the legislator in the halls of Congress. You also want to include the time you spent preparing for that meeting, your travel to get there. All of that is going to count as part of your lobbying effort. Next, your communication must be directed towards a legislator. So that is someone who is a lawmaking official. It could be any level of government, so it could be federal, state, local, regional, tribal, international. And it could also include the legislator's staff. So it depends who the staff member is. For example, if you get the receptionist, and you're just scheduling a meeting, that's not going to count as lobbying. But if you end up on the phone with, the policy director who's actually writing legislation, that would count as lobbying as well. And then this is an interesting peculiarity. So when the general public is voting on a piece of legislation, the public becomes the legislator. So efforts for that piece of legislation are direct lobbying. So this is for ballot measures, propositions in California, bond measures, constitutional amendments, any piece of legislation that's on the ballot that the public is voting for. In that instance, the public becomes the legislator. So this is kind of interesting. It means that it is direct lobbying when you're doing proposition work rather than grassroots lobbying, even though you're talking to the public. But that's kind of nice because if you remember from that pie chart, you have more to spend in your limit on direct lobbying. So all proposition work going to be direct lobbying. Keep in mind as well, in some states, you may need to register if you're going to be doing proposition work or ballot measure work, depending on what state you're dealing with. So just check that out if you're going to get involved. Okay, and then executive branch officials are sometimes legislators. So usually an executive is there not to make the law, but just to execute it. But in some instances, we do see executives serving a legislative function. So an example of this is when the governor is signing or vetoing a law that came over from the legislature. So that signature or veto, that is a legislative act because they're making the decision there on the piece of legislation. So if you write a letter to the governor to say, please veto this bill, it's terrible, that is going to be lobbying. But most work you're doing with the executive branch at any level is usually not going to be lobbying. And because of that, there are a lot of government officials you could be working with or want to persuade that aren't involved in lawmaking. And so working with them or trying to persuade them is not going to count as lobbying. So to be a legislator, you have to have plenary power, which means you can make law in a wide variety of areas. So think of, a state senator, a federal senator. They can make law about anything that affects their constituents, really. So that means that if you want to work with police, district attorneys, zoning commissions, housing authorities, school boards, things like that, those are not lawmakers with plenary authority. So any work you do with them, any persuasion of them is not going to be lobbying. And then finally, for it to be lobbying, you need to be expressing a view about specific legislation. So there's really two parts there. There has to be specific legislation, and you need to be expressing a view about it. So specific legislation it includes anything that a legislative body is going to vote on. So that could be a bill with a formal bill number. It could be a budget. It could be draft legislation that's not being voted on yet, but it's still being written. And it could even broadly include if you identify a problem that needs a legislative solution. So if you know that to accomplish whatever you're asking for, there's going to need to be a bill, that will count as lobbying. It's also going to include things like votes on nominees for judicial or cabinet positions. Here we have Ruth Bader Ginsburg. If you're voting on confirming the next Supreme Court justice, persuading the Senate to vote yes or no on that person is going to be lobbying as well. This is kind of nice because it is a little area, you can't usually express an opinion about a candidate for office, but you can if there's someone that's being put into place because they're being voted on by the legislature. And so then the second part of the definition is that you need to express an opinion about that piece of legislation. So that could be saying vote for the bill, don't vote for the bill, vote for the budget. But it could also be more subtle, like just showing support or saying, this will be really beneficial to the communities I work with, using value-laden language. All of that can be showing support. Basically, if the legislator can tell how you want them to vote, then that's probably lobbying. But keep in mind, if you take out that part, if you don't say what your position is or how you want them to vote, then what you're doing is really just educating the lawmaker about the bill. So if you go in and you say, here are all the facts, and that's it, then that's not lobbying. That's just education, which is just advocacy. So there's no limit on how much of that you can do. It's just when you pick a side, when you encourage them to vote one way or another, or they can tell how you want them to vote, that's when it is going to be lobbying, which again, not a problem that it's lobbying. It just means you need to track it and report it. So there are a lot of things that are not going to be specific legislation that you might want to argue for or against. So again, the executive branch, most of what they do is not legislation. So regulations, executive orders, we're seeing so much of this right now, enforcing existing laws. None of those are forming new law. So if you want to support or oppose all of these executive orders that are coming out right now, that's not going to count as lobbying. It's just advocacy work. Keep in mind, again, there might be requirements to disclose that work, depending on what level of government you're working in. So just keep that in mind if you're going to be doing executive order work. Another example is litigation and lawsuits. Those are not legislation, so you could, spend unlimited time in a lawsuit and that won't count towards your lobbying limits. Okay, so we'll do a little quiz and see if you can identify some direct lobbying. So in this scenario, staff of your 501c3 are taking a trip to Congress to tell legislators to pass the Transnational Repression Policy Act. Would this be lobbying? So if you guys, I think I'm not sure if you have access to the chat. I think so. If you could put in the chat, if you think that this is lobbying, let me know. Yes for lobbying, no for not lobbying. If I don't see any answer, they'll assume you can't use the chat.
Yes. The room says yes, Brittany.
Great. Okay. Yes. Yes. Perfect. I'm seeing some yeses. So that's exactly right. This is going to be direct lobbying. So let's go through the parts of that definition. You are communicating to the legislators in person. That is a communication. It's to a legislator. Here it would be members of Congress. The legislators here are the ones who are voting on this specific act. So we have the specific piece of legislation, that act that's up for a vote, and you're expressing a view. Sign this into law. So this is pretty clear direct lobbying. What's the significance of that? Again, it just means you need to track it and report it towards the IRS. It goes towards those caps, but it's not a red light. Lobbying is not a problem. You just need to keep an eye on how much you're doing. Okay, here's another example. This is a communication from the League of Women Voters. This was on social media, and it explains how you should vote on each of these propositions that were on the ballot. So is this lobbying? Yes for lobbying, no for not lobbying.
We're hearing both yes and no.
Okay, I love that. Mixed reports. So this is going to be direct lobbying. So let's go through the points of that definition to see why. So there's a communication. This is a social media post that's communicating. It's to a legislator because remember, in propositions, the general public is the one who's voting. So the general public is the legislator. And then there's specific legislation here. We have 7 different propositions. Each one of those is a specific piece of legislation. And there is a view expressed. Here we have vote yes, vote no, more neutral. So that is expressing a view about these specific propositions. So again, that's a tricky one, but keep in mind in this instance, it's kind of good that it's direct lobbying. It's just going to count towards your lobbying limits. But again, it's something on the ballot that a 501c3 is allowed to engage with, express an opinion on, and it's not going to count towards your grassroots lobbying limits. Okay, one last example. So this is a post from Blue Sky, it's on Blue Sky from America's Voice. So it says Trump's latest executive order is a direct attack on the 14th Amendment, which establishes the principle of birthright citizenship. Children born to immigrants, whether undocumented or on temporary visas, could be denied their citizenship. This is unjust and un-American. Do we think this is lobbying?
We're hearing no.
It has to be one no.
Great. I'm hearing no. Okay, so that is exactly right. Not lobbying. So let's go through those points. There are a few reasons this isn't going to be lobbying. So we do not have a communication directly to a legislator here. So that's our first issue. Trump, even if we consider, maybe this is intended to be heard by Trump, Trump is not a legislator. He's an executive. Here, this isn't a proposition, it's not a ballot measure, so it's not the public who could be the legislator. So really here, nothing is being directed to a legislator. So that means we do not have communication with the legislator. It also doesn't express specific legislation because remember, an executive order is not a law, it is not a piece of legislation. And it's not expressing a view on pending legislation because this has already happened. He already made this executive order. It is caught up in the courts, so it's not implemented fully, but it's not something that's about to be voted on. So for all those reasons, this is not going to be direct lobbying. It's not going to be grassroots lobbying either. And so it won't count towards your lobbying limits. And this is a perfect example of making a statement about an executive order or educating the public about an executive order without it being lobbying. And that's just that great advocacy work that you can do as much as you want to. Okay, so let's move on to the other type of lobbying under the 501(h)(10), and that is grassroots lobbying. So again, the two differences between direct and grassroots are that grassroots lobbying is going towards the general public, and then there's that call to action. So here's an example. We have a communication. This is a post on Blue Sky, which is social media, and it's going out to the general public because it's on social media. It's expressing a view on specific legislation. Here, they want Congress to know that they will not accept cuts to Medicaid. This is about, current budget talks. The budget is something that's going to be voted on by the legislature, and they anticipate that it will impact Medicaid spending. So here we have, it's directed, it's a communication, it's to the general public, it's about a budget, specific legislation, and then there's this call to action here, which is that it gives you a hotline number that you can call, you can enter your zip code, and it will connect you directly to your representative. So let's talk about that call to action. What's going to count as a call to action? The IRS definition of a call to action is pretty specific. It's not the way you or I just use the term call to action, which is nice because it means fewer things are going to count as grassroots lobbying. So for it to count as a call to action, it needs to either be one of four things: telling someone to contact their legislator, providing the legislator's contact information. That could be their phone number, their physical address, their email address, their social media handle, or providing a mechanism to contact a legislator. You've probably seen this before. It's like those forms that pop up and you just put in your name and address and then it sends it to a legislator. That's the best example of that. And then the last is an indirect call to action, which is just identifying the names of the legislators who are either going to be voting on it or who might be swing votes or who are on the committee that's reviewing it. So these are the four calls to action. And again, they're pretty specific. So things like just saying, take action, do something, learn more, none of those are going to meet this definition. You have to be doing one of these specific four things. And if you're not, then whatever you've just done is advocacy. It's probably educational. It's not going to be grassroots lobbying. Okay. So here is an example. Let's see if this is going to be grassroots lobbying. So this is a post on social media. The post says, "What will SB 48 do?" And it describes 3 things that the bill would do: make a safe zone against ICE, prevent a drop in attendance, and protect information of students and their families. So do you all think this is grassroots lobbying?
No.
Yes. We hear yes and no.
Oh, lobbying, no.
Or no, not lobbying.
Okay. I'm hearing mixed things, but mostly no. So correct, this is not lobbying. So let's go through those steps. So we have a communication. Yes, this is a social media post. It's to the general public because it's on social media. It is about specific legislation because it's about SB 48. It names it right there, but it does not express a view on this specific legislation. Here, this is just listing what the bill will do. It's pretty unbiased in its language. So that's just educating the public about what this bill would do. And is there a call to action? No. It's not saying call your legislator now. It's not providing their phone number. It's not providing a form to send them a message. It's not naming the people who are voting. So this would not be, can you all still hear me?
We can hear you, Brittany.
Sorry, something popped up on my screen that said my microphone had changed. So yes, there is no call to action. So remember, keep that in mind. This is a great example of work you could do if you want to be not lobbying, or if you're close to your lobbying limit, or you have funds you need to use that restrict lobbying. Something like this, informational about legislation, is a great way to work around that. Okay, so we talked about direct and grassroots lobbying, what the definitions are. Now we're going to talk about the 4 exceptions for things that might otherwise be lobbying, but the IRS has said specifically that they are special exceptions. So those are nonpartisan analysis, research, or study, requests for technical assistance, self-defense, and discussions of broad issues. So the first exception is called nonpartisan analysis. An example of this is like a detailed policy report. It's more than just a fact sheet. It's like a dense policy report. You've probably read these before. So there are 2 elements here that you need to meet this exception. The first is that you have to have a broad, complete, and fair discussion of all sides of the issue that would allow someone to reach an independent conclusion on the subject. And the second is that it needs to be broadly disseminated. So if you do those 2 things, if the coverage is broad, it's available to the public, then you are allowed to express an opinion on a piece of legislation. So you're allowed to do the whole analysis and then come down on one side or another. You cannot include a direct call to action, but you can include an indirect call to action. So remember, that is just naming legislators who might be voting on this or who are influential. But you are allowed to do that if you meet those fair, broadly disseminated things. So you want to be careful here. If you get this wrong, then the whole thing becomes lobbying. And that is an expensive research project that you've just done that you would need to count as lobbying. So if you're going to do this, you might want to check with your lawyers, make sure it's a discussion with your whole organization. But what's really nice about this is that if you do a study like this, it's not going to count as lobbying for you, and your allies who might be doing lobbying work can use it to support their lobbying. They could bring it with them to the representative and say, look, like, here's the research. And they won't have to spend the money to do the research, and you won't have to count it as lobbying when you do the research. So if you're going to do that, there are a few time limits that apply. You might need to, do some planning to work this out and work with your partners, but it's a great option if you have the resources to do a study like this. Technical assistance is the second exception. This is pretty narrow. So this is when the organization gets an invitation to provide expertise on a subject matter. So think of this as like testifying before Congress. It needs to be a written formal invitation to just your organization, and it needs to be from either the chair of the committee or the full committee itself. And the testimony you make needs to be available to all the members of the committee. So those are some specific requirements. But if you get an invitation like this, you can go and you can lobby, and it's not going to count as lobbying. So you can talk about legislation, you can express your opinion on the legislation. None of that counts as lobbying. Your travel to get there doesn't count as lobbying. None of it has to count. So one of my colleagues calls this the permission slip, because basically it lets you just lobby for free. But it's a very specific invitation that you have to get. So this is not the same as, we do what we call technical assistance, which is just answering questions. That does not fit this exception. For example, another thing that would not be this is if a committee calls for comments on a bill and just asks the public to comment, that's not going to meet this exception either. It needs to be a written invitation specifically to you saying, we want you to come and talk about this. But if you get that, great exception. And the third is self-defense. So this is a pretty rare exception. If you think it would apply to you, check with a lawyer. Unfortunately, it's becoming a little less rare these days, but essentially this is when an organization talks to the legislature about legislation that's going to affect their right to exist. So it's a big existential threat to your organization, not just your subject area or you specifically. It's something like if the government or if the legislature decided they wanted to eliminate 501c3 status. Something big that would prevent you from existing. Could be something about like the duties of your board, big issues for the way that you run the organization itself. So this wouldn't be personal to just you. So for example, if you're funded, you get funding from the state and they decided in the budget they're going to reduce that funding, that wouldn't count. It has to be something big and existential, not just a little personal attack to you. And this exception also is only going to apply to direct lobbying. So you would be talking directly to legislators about this issue that's impacting your organization's ability to exist. Again, rare. And then this final exception is a bit wonky. It is examinations and discussions of broad social, economic, and similar problems. Basically, this is if you're talking to the public or to the legislators about general topics, not specific legislation and not encouraging specific action. So if you've been paying attention up to this point, you would know that that would not be lobbying anyway. But the IRS wants you to really understand that this is not lobbying. And so they make it an explicit exception as well. But you can think of this as, a roundtable discussion, a panel, something where you're just talking about broad issues, not specific pieces of legislation and how you want them to vote or not vote. If you do this broad discussion, and at the end, the legislator says, so how do you think I should vote on this piece of legislation? That's lobbying. So make sure you don't cross that line. This again, most of these exceptions, you want to tread carefully. They probably are not going to apply. Okay. So we're wrapping up and we'll open it up to Q&A soon, but just some takeaways to remember. Most importantly, 501c3s can lobby legally, and you should not be afraid to do it. You can really make a big difference. You have a voice that's important to share. So learn these rules, learn the IRS rules, check out our resources, and let them empower you to be able to lobby and not be scared to do it, to know that you are acting within the law. Keep in mind those IRS caps on lobbying, that you might have disclosure requirements at the state and local level, but remember that those are not red lights to your lobbying. It's just paperwork. And then keep in mind that we are here to help. We have a lot of resources available on this topic and many more. We have a lot of other workshops. As we mentioned at the top, this will be a series, so this is just the first training of these that we'll be doing for you. And you can check out our website if your specific organization is interested in having us do a training for you as well. We do have state-specific lobbying guides that address those state disclosure requirements that I was talking about. Here's the California one here pictured, but check that out if you're planning to lobby at the state level. There's some good state-specific resources there. In our guide, Being a Player is our big lobbying guide that goes over all that we discussed today and much more, and goes into a bit more detail if you're interested in learning more. And then there's also here that keeping track resource that's mostly about record keeping that I mentioned earlier. So this QR code will take you to our resource library that has loads of information on lobbying and many other topics as well. And then I'll also plug our podcast, Rules of the Game. We have a new episode every other week, and it just addresses a little area of nonprofit law, and makes it really digestible. So I highly recommend that. I just recorded an episode. I think our episode next week will be on working with undocumented activists. So check that out, subscribe. It's easy to understand, and just tiny little tidbits. As I mentioned, we also offer technical assistance for your more detailed questions. So we have our technical assistance line, which can be reached by filling out the online form that this QR code links to. You could also call us, email us, and we're available on all forms of social media as well. All right, and if you have a moment, fill out our survey, let us know what you liked, what you didn't like, but I am happy to answer any questions we have. Do we have any?
What would
I can't.
Okay, Brittany, I have folks in the room who have questions, so I'm just going to repeat what they're sharing.
so
What
you're going to like the
would
city hall and you're doing a public comment
public comment at City Hall
or like a school board meeting?
or a school board meeting, would that be considered lobbying?
So if you go to a school board meeting on behalf of your organization, and let's go through the elements of direct lobbying to see. So that would be a communication. You're showing up in person, talking to them. It would be so it depends who the meeting is with, right? So school board is not going to count as a legislator because they don't have that plenary power to make law in a lot of different areas. If it was like city council that has that plenary power, then that would be a legislator. And if you're talking to them about a specific piece of legislation, like a bill is coming up or they're working on the budget, and you're telling them how you want them to vote, then that would be direct lobbying. So it's going to depend, who the panel is that you're talking to, and what you're advocating for. So if it's something that needs a law to solve the problem, and something that they're going to be voting on, then that would be direct lobbying.
So we
Or
have a
you-
specific
yeah.
example. If the school board is talking about an ethnic studies bill
Or curriculum or something.
or a new curriculum,
So was that the question? Oh, was there more to the question?
That was it.
Okay. So, essentially the school board in most instances is not going to count as a legislature. So that would not be lobbying. But if you're talking to the school board and it's like a bill that's going to be going through the state legislature, that is still not going to be direct lobbying if it's in front of the school board and they're not the ones voting on this. If it's the state legislature that's going to be voting on it and you talk to them about it, then it would be direct lobbying. You could start bordering on grassroots lobbying though. If you show up and you say, here is this bill, I think it's terrible. This is how like we all should be voting and we should all need to call our state senators and tell them how to vote. Then that could be grassroots lobbying. So keep that in mind, but because the school board themselves is usually not going to count as a legislator, advocacy with them would just be advocacy and not lobbying.
Thank you so much, Brittany. We have another question in the room.
Lobbying if you work at the organization, but you don't claim it.
It's a follow-up question to what you just answered, Brittany.
Oh, you're on mute.
Sorry, thank you. What if you show up as an individual and you're not representing the organization? Does that change anything?
Yes. So basically these lobbying limits that we're talking about apply to the organization. So those caps, if you're working in your individual capacity or you're just volunteering, you're just going to the meeting to say your personal opinion, that's not going to count towards your organization's caps. You just want to make clear that you're in your personal capacity and you're not representing the organization. And keep in mind, if you do this a lot, you still could become a lobbyist in your personal capacity. So just keep that in mind. That's usually not a problem for anyone, but like if this becomes your whole side hustle and you're doing a lot of it, you might want to check your state rules.
Thank you, Brittany. Another question we have is, in a typical nonprofit, who should keep tabs for that organization's lobbying activities?
Yeah, good question. So it's going to vary based on your organization, based on how big you are and how much staff you have. Like I said before, the IRS doesn't really have specific guidance on how to keep track of this. So it's whatever is going to make the most sense to you. Probably makes sense for it to be the same person consistently tracking it. But for example, like I said, we use our timekeeping system. So it collects everybody's lobbying numbers, and then our HR administrator is the person who's looking at those numbers and processing the timesheet and then keeping track of it on our administrative side. So it's going to depend, if you're a small team, you could just keep records on a piece of paper. We've seen like charts that do this. We do have some examples of charts to use to track your lobbying if you want to do it by hand on our website. I think that's in the keeping track resource. I believe it's in the appendix. So there are a lot of ways to do it depending on how much staff you have and if you have someone who can just keep track of that for you versus if you, the person doing the lobbying, might need to be the one to keep track of it as well.
Thank you so much. Another question we have, if you can share, if you know, how has the IRS enforced lobbying limits and rules?
Yeah, good question. So we don't see a lot of enforcement. And that is not to say, so we do these trainings, we're going to tell you what the law is. Your chances of being audited are probably low. It depends how, vocal you are about your lobbying or if you're creating enemies in the process. But we're not seeing a lot of IRS enforcement. We also saw, I think just last week, they laid off like 6,000 IRS employees. So there's a reduced capacity in the IRS as well. And we don't know what their priority is going to be in this administration. So, we encourage you to follow the rules, to report everything like you're supposed to. But we have not been hearing many reports of people being investigated for their lobbying and getting close to that limit or passing it.
Mm-hmm. Thank you, Brittany, for sharing what you've been hearing or seeing. Another question, it's related to the self-defense the topic that you shared. With this administration, coming after nonprofits like fall under that topic. For example, some partners are hearing or talking about a plan that they're to revive a bill that allows the AG to take away 501c3 status. We don't remember the exact bill number, but would that fall under self-defense? HR 9.
Yeah. HR 9495. Yeah. Yeah. So this is a very good question. HR 9495 essentially, like you said, empowers the Secretary of the Treasury to unilaterally declare that a 501c3 is a terrorist supporting organization, and then it revokes their 501c3 status. This passed the House last year and didn't make its way to the Senate before the year ended. We are expecting it might make a revival. We have a different congressional makeup now. That being said, the general consensus last year when it first surfaced was that this would not count under the self-defense exception. While it would be a threat to C3 status, to say that it would be a threat to your C3 status would be to essentially admit that you were a terrorist supporting organization. So the way we came down on this was essentially that would not be a good use of the exception, just because it's a little complicated by the terrorism issue in there. But that is a good example of something that's getting close. That we could see similar bills that say, the Treasury Secretary can just revoke your status, period. That would be a threat to the ability of your organization to exist. The terrorism support kind of makes it hard for this exception to apply here.
Thank you, Brittany. And then another question is, can you provide examples of lobbying expenses?
Yeah, great question. So there's going to be direct lobbying expenses and things like overhead costs too. So again, our keeping track resource goes into depth about this a bit as well. But things like, think of anything that would have a receipt. So you buy a train ticket to go to the Capitol to lobby. That's going to be a lobbying expense. You spend staff time researching and having a meeting and making a plan for your lobbying trip to Congress. That's something, staff time is a quantifiable expense that you would want to count towards lobbying. But then you also want to look at, if your organization does say 10% of your total activity is lobbying, then you should also count 10% of your total overhead expenses as lobbying. So that would be things like office space or, insurance for your employees, things like that. You would want to count the portion of those overhead expenses that go towards your lobbying efforts as well. But it's mostly going to be those things with the receipts and the things you're, already paying for just to keep your organization running.
Thank you so much. We're going to do one last check if there's any other questions in the room or virtual room. Chloe, is there anything I missed? Any questions I missed? No? Okay. Well, thank you so much, Brittany, for answering all the questions and for the presentation. Is there any last comments you'd like to share before we wrap up?
Just we'll send out the resources I mentioned today. We'll send a follow-up email that you can forward along to everyone. And if you have any specific questions about how lobbying can work for your organization, feel free to reach out to our technical assistance line. We have an attorney manning that every day, so someone will get right back to you.
That's great. Thank you, Brittany. And thank you everyone for spending your morning with us. It looks like you'll be getting some time back. We hope you learned something new, and we hope that you'll join us at our next two trainings with Brittany and Alliance for Justice, which will be on May 6th and July 1st. Same time, same registration link. Again, we'll share the slides from Alliance for Justice, and we will be sharing the recordings to these policy webinars to all those who registered and also post on our website. So keep an eye out for that. I want to reiterate what Katie said in the beginning of the webinar, that CBOs are powerful advocates. No one knows the issues better. And we're sending strength to you all during this time. Have a great day and a great rest of your week. Thank you for joining us.